Hello everyone, greetings to all watching the video. I welcome you all to another episode of Convo with Apricus. Friends, this session is a continuation of previous one where Dr. Shalini Rohilla Panigrahi will enlighten us on the topic recovery proceedings under IBC, SARFAESI Act and DRT Act. Let's start the discussion, ma'am.
Okay, thank you, Rishu, for introduction. So I'll start by sharing my screen. It is still showing the host has disabled the part. Can you please enable? Hello.
Yes, ma'am.
Can you please? Now. Welcome all. Today I am going to discuss about the recovery proceeding under IBC, SARFAESI and DRT Act. So let's begin. Now, recovery of debts which are due to the banks and financial institutions is served under various insolvency proceeding and bankruptcy of individuals and partnership firms Act were earlier covered under DRT Act 1993. Now, the procedure in DRT, that is the Debt Recovery Tribunal, will be studied in this module. We have to begin by filing of an original application for recovery of the dues with DRT. If a financial institution is aggrieved, some default has been committed by the borrower. Now, what is the remedy with the financial institution or the bank in that case if the dues are more than 20 lakhs? So we can approach debt recovery tribunals by way of filing of an original application, that is OA. In short form, we call it OA, for recovery of the dues with DRT, debt recovery tribunals. The condition for that is, first of all, the dues which are legal dues, they should be more than 20 lakhs or more. If the dues are less than 20 lakhs, we cannot approach DRT. We have to go for a filing of a civil suit in a civil court. Now, OA, that is the original application, can be jointly filed against the borrower as well as the guarantors. As we know, in the Indian Contract Act, the liability of the borrower and the guarantors is coextensive. So the guarantors are equally responsible for paying of the dues as the borrowers. Their liability is coextensive unless and until the contract provides otherwise. If the contract is providing that only the borrowers are liable and not the guarantors, or guarantors have a limited liability, so it will apply like that. Otherwise, if the contract is not providing for that specific feature, the borrower and guarantors liability is coextensive. That is well provided under the Indian Contract Act, Section 128. The maximum application fees for filing of the OA in DRT is 1.5 lakhs. In joint funding case, suppose there are two lenders who have funded the project, joint application or other lenders be made pro forma defendant. One of the lenders who is a lead lender will be the primary and the other will be like pro forma defendant, or they can make a joint application before the final order is passed. Now, when the OA is filed, the borrower, who is the guilty party, now he will act as a respondent and he has to file the reply within 30 days. That is also known as counterclaim. Claim set of counterclaim, and they have to submit the evidence in their defense. So this is the procedure which is followed in DRT. That is the Debt Recovery Tribunal Act 1993. Now, when all the proceedings are completed, the pleadings are completed, the Debt Recovery Tribunal will decide the OA as expeditiously as possible. This act came with the force, and especially it was designed so that the these dispute of lenders are expeditiously decided, and endeavor should be made to decide in 180 days. So there is a limit of 180 days because we can't keep lingering on the proceedings. So this was a speedy recovery of the dues. In DRT, they are not bound by CPC. CP means CPC, that is the Civil Procedure Code. They are not bound by that procedure. They have not to follow each and every step, like pleadings and everything, evidence and everything. But still, they follow the procedure, not strictly as per the CPC, but still they follow that. They are guided by, on the other hand, they are guided by the principle of natural justice. Now, what is natural justice? We all know that both the parties should be given equal opportunity. There should not be bias, and you cannot decide by listening to one party. You have to listen to both parties. You have to give them equal opportunity. You have to decide without any bias. Power to issue interim orders. Now, DRT has got the power that they can issue the interim orders, stay orders, attachment before the judgment. Even before the judgment, they can pass an order for attachment of the property of the defaulter borrower. Then they can appoint receiver on the behalf of court who will see all the recovery proceedings, and also they can pass an interim recovery certificate. Now, this recovery certificate is a certificate which is passed before the judgment or when the judgment is passed. In that, it will be clearly written that the borrower are liable to pay this amount with this much interest. The final order and the recovery certificate passed by the debt recovery tribunal, normally it allows the whole OA amount which has been claimed by the lender, pendentility and future interest. Means pendentility means the interest which is awarded by the court during the court proceedings, and future interest, generally it is passed like 9 to 12%. And even cost means legal cost and other costs which are incurred by the lender as it thinks fit to meet the end of justice. So generally the rate of interest passes 9 to 12%. It is not that amount, that interest which we have claimed in the OA, because we will claim as per the contract, but a court will not allow that much of interest. It will go according to the norms. Agreed party, suppose that judgment has come out. Now what the agreed party can do, they can file an appeal within 30 days. So only 30 days are given. Suppose I as a lender has filed an OA and the OA is decided against me. So what remedy I am having? I can go for an appeal before Debt Recovery Appellate Tribunal, DRAT, because these DRAT, Debt Recovery Appellate Tribunals, are appellate authorities of DRT. They are not found in every state. 3 or 4 states, like one DRAT, will go for 3 to 4 states. That period may be extended for a sufficient cause, but not. It cannot be like indefinite. It that is also the discretion of the court whether they grant that stay or not. Whether they grant that extension or not. So we have to be very vigilant. Within 30 days, we have to file the appeal. If the RC debtor file an appeal, if the debtor is filing an appeal against the lender, they have to deposit 50% of the RC amount. This is very important. But if the lender is filing, they have not to deposit any amount. If the debtor is filing an appeal, they have to deposit 50% of RC amount. Now, why this provision is there? So that frivolous appeals are not entertained. 50% of RC amount is not easy to pay. So this is avoiding the frivolous appeals. Now, DRAT can reduce the amount which shall not be less than 25% with reasons recorded. DRAT can only reduce the amount, but it should not be less than 25%. Appeals to be decided expeditiously as possible. And finally, the decision should come in 6 months' time. So DRAT also cannot linger on. They have also to decide that appeal as quickly as possible. Now, when this final order has passed, now the proceedings will come back to the recovery officer of DRT, and he will execute the recovery certificate. Execution of recovery certificate means he will implement that decree. He will either auction it or whatever procedures are there under the DRT Act. He will execute that RC. Now, RO has what recovery officers are powers he is having. He can issue garnishee orders. He can pass an order for attachment of the property which is mortgaged with court, with a lender. He can pass an order for attachment. He can pass an order for sale of movable and immovable secured assets of the debtors by following procedure as per the rules. RO can also attach an auction sale, unsecured assets of art, not even secured. He can also attach unsecured assets also, which are not, which were not secured as secured for the loan. He can also pass those orders. He has to realize the decree, so he can do these things to realization of the decree. RO has the right to send the RC debtor for civil imprisonment. So these provisions are there just to implement the decrees. Our motive, the DRT was enacted with a motive to clear the dues of lender, because that is a public money which is at stake. So this act was a very effective act at that time. Amount realized will be utilized for satisfaction of RC. Whatever amount has been realized after the selling of the property by way of auction sale, that will be utilized for the satisfaction of the recovery certificate. In the recovery certificate, whatever the amount is given, that if amount is realizable, after that, the amount will be returned back to the debtor. Now, the DRT Act was very good step towards the recovery, but that was not found to be sufficient. Therefore, the steps were taken, and there were a lot of thought process was there how to make these defaulters, how to realize the amounts which were taken by these defaulters, how to clear the these defaults. So this led to the enactment of Securitization and Asset Reconstruction of Financial Assets and Enforcement of Security Interest Act. This act came in 2002. So as the name suggests, this act was specially designed to enforce the security. Security means what the security was given for the loan, the mortgage assets or hypothecation, etc. So this is a very important step in this clearing of the defaults. So what are the main features? Here, the right to transfer by sale or lease secured assets without the intervention of the court. The court will not take part in these proceedings. These proceedings can be initiated by the lender itself. The authorized officer of lender will be the authorized officer of SARFAESI, and he will take all the proceedings. He is the court in that. So there is no interference of court. These are parallel proceedings. Now, question may be asked that if the DRT proceedings are going on simultaneously, can SARFAESI action be taken? Yes, SARFAESI action can be taken simultaneously. Right to take over the management of the business of borrower, which includes right to transfer by lease, sale, and to realize the dues which were to be paid to the lender. No right against the unsecured assets. This act is specially designed for the secured assets, not for unsecured assets. And what are the prerequisites of this act? Action can be taken if the account is in default. Default means failure in payment of legal paid dues. The dues which are payable, which has to be paid by the borrower, are not paid. So the default is committed. He is failing in payment of the installments. The account becomes NPA, means non-performing assets. And if the total dues are more than 1 lakh, this action can be initiated on these conditions. In joint financing case, consent of not less than 60% in value of the secured assets. If there are more than 2-3 secured assets, if it's a joint funding case, then the consent has to be taken of not less than 60%. This means that most of the lenders should agree. Otherwise, the SARFAESI action cannot be initiated. Now, what are the procedure? In brief, it is the authorized officer of the lender will issue a demand notice, because without notice, the borrower will not come to know about what action is being taken against him. So this is also principle of natural justice, that notice is given to the borrower, and he is given only 60 days time to clear the default. That notice is given under section 13(2) of SARFAESI Act. On such notice, the borrower, whenever he is getting that notice, especially there is condition in that notice that borrower will not transfer by way of sale, lease the secured assets. Whatever secured assets are there, they have to be kept intact. Now, the borrower, if he is aggrieved, he is also given right to file representation or objections within the time frame. Now, secured assets to creditor to consider and reply on the objections within 15 days. Now, as I told you that this is not a court proceeding, everything has to be done by the lender. the lender's authorized officer will see those objections and he will reply within 15 days time. And the reasons of non-acceptance of the objections be given. So 15 days time is given to the secured creditor. Now AO is authorized officer. Authorized officer, now what he will do? He will take the possession of the secured assets. He may also apply for taking of the physical possession of those secured assets. He needs police security. So he will file an application with the district magistrate or the chief judicial magistrate for taking the possession. And he will get the assistance of the court by way of police forces and etc. so that he can take the possession peacefully. After taking the possession, what he will do? What the authorized officer of the lender has to do? He has to make public notice in 2 leading newspapers within 7 days. Thereafter, after giving of the notice, he will issue public auction sale, giving 30 days time in the newspaper and website. So that notice should be given to all. Notice should contain necessary details like what will be the reserved price, what will be the earnest money, date of auction, etc. Borrower can make payment before the date of publication. This notice is given so that the borrower has the chance to make the payment before the date of auction. He can even pay the money before the date of auction, so the auction will be cancelled in that case. Generally, but this doesn't happen. The borrower is a notorious guy. He will not make the payment. Had he been a just person, he would have made the regular payments. In auction, highest bidder has to deposit. So this will be a very fair process. Now it is done by e-auction process. Otherwise, it was a physical auction was being held, but now e-auction is being held. So in auction, highest bidder will deposit 25% immediately and balance in 15 days time. When the amount is received, the sale certificate is issued, that also by lender. So there is no interference of court. So this act was coming as a blessing in disguise for the lenders. So this was a positive step. In DRT, the things were lingering on. The defendants or these borrowers, they used to bluff the court. They used to take adjournments. After adjournments, no procedure was followed. No time. Speedy justice was very far off. It was like a nightmare for these lenders. So this act came as a blessing, and it proved very beneficial also. I also work in a housing and financial corporation, and even I was a SARFAESI officer in my regional office. When I was posted in Patna, we solved many cases by taking SARFAESI action. For balance dues against borrower guarantor, HUDCO to file a revised OA before DRT. Now, if after taking the SARFAESI action, if also some dues are left, then for those balance dues, the borrower or the guarantor, so that is HUDCO in our case, I have taken the example of HUDCO, we can file a revised OA before DRT if we have not taken the action earlier. If auction fails, secured assets can be again auctioned and reserve price can be reduced. So if the auction fails once, the auction can be held again. If auction fails due to want of bids, HUDCO or the financial institution has the right to purchase assets in subsequent action. Purchase price to be adjusted against the borrower. Such acquired assets to be used for sell or resold within the 7 years. Affected party can file an application before DRT within 45 days and DRT to decide the matter as expeditious as possible within 60 days time. If the auction failed due to the want of bids, that affected party can go before the DRT within a period of 45 days. Further, if they are still aggrieved by the decision of DRT, they can file for an appeal before DRT within 30 days on the deposit of 50 days, 50% of the demanded amount, or adjudicated by DRT, whichever is lower. Again, this provision is so that they are not going for filing of any frivolous appeals. DRT has to give a reasoned judgment. DRT may, for reasons to be recorded, reduce the amount, but that should not be less than 25%. So one very important thing is SARFAESI action cannot be taken against agriculture land or when dues are less than 25%. So if the secured assets are in a form of agriculture land, SARFAESI action cannot be taken. So this is a drawback. Simultaneous action under SARFAESI and DRT are possible if we have filed a DRT suit. As I already told you, if DRT action has been taken, you can simultaneously also proceed for SARFAESI. So that prudent decision has to be taken by the financial institution, that if the DRT proceedings are on the verge of like finishing, if your dues are like you are able to sell the property, so why you will take SARFAESI action? Why you will waste the time and money of the you will not waste the time of the officer. But if you are seeing that DRT proceedings are lingering on, simultaneously you can take the SARFAESI action, and that will be a quick remedy. Loans can be securitized by way of sale or transfer to even ARC, and realized amount to be adjusted. No stamp duty is applicable. Now, after seeing the provisions of DRT, SARFAESI, a need was felt, and a very recent code has been enacted for the defaults to be clear, because even these DRT and SARFAESI Act were not able to solve the purpose. So this code came into the force after various discussions. This code was enacted in 2016. So this presentation of mine will be just giving a brief, very briefly, it will introduce the IBC. Later on, we are going to have many modules on IBC, because it's the very upcoming act and very dynamic and very variant act. And I think the lawyers, the students, they should be like keen to understand this IBC. What is IBC? Insolvency resolution and liquidation process for corporate debtor. Corporate debtor means the person who has committed the debt. If corporate debtor commits defaults, if corporate debtor is committing any default, that is, he is unable to pay the loan installment, the creditor, the term used is financial creditor, operational creditor, or the corporate debtor. It's very interesting. Even the corporate debtor can initiate insolvency proceeding against itself, because this act was designed in such a way that the defaulter himself, he wants to like survive, he wants to revive himself. So he wants to he can go for the insolvency proceedings, so that his company is bought by some good person, able person, so that will be going as a going concern. Minimum default amount was till now it was 1 lakh, but now the recent update is that it should be 1 crores. That I will update in my next slides, next modules. The financial creditor itself or with other financial creditors can join the process. It is either the financial creditor himself, or in case of joint funding, the financial creditors can jointly initiate the process of IBC. Briefly, I will tell you about this. The application with records of default with information utility. Other records of default, proposed name of interim resolution process. Interim resolution professional is a person who will take charge of the IBC of your company. Once the IBC proceedings are admitted, now the company will go in the hand of interim resolution professional with NCLT, which is the adjudicating authority in this case. NCLT has to see within 14 days time whether the default has occurred. If NCLT is satisfied that default has occurred and there is no disciplinary proceeding against the interim resolution professional, it will admit the application. And if default has not occurred, application not complete, or disciplinary proceeding against IRP, if these 3 conditions are not satisfied, it will reject the application. So who can file the application before for this IBC proceedings? The financial creditor, operational creditor, or the corporate debtor himself. After filing of application, 14 days time, NCLT is taking. National, these tribunals are designed. It will take 15 days time, 14 days time, sorry, for the deciding whether this application is admitted or rejected. Before rejection, it has to give notice to applicant to rectify it. 7 days time are given for the applicant to rectify it. Almost similar procedure is there for operational creditor and corporate debtor. Similar procedure is there. In case of operational creditor, who is operational creditor? The creditors which have given service to the debtor, like he is for goods and services. He has to give a demand notice, has to be first issued, and if no pre-existing dispute raised by CD within 10 days. For corporate debtor himself, corporate debtor also can initiate IBC proceeding against itself. But for that, who is a corporate debtor? It's a company. It can be partnership firm or LLP, that I will discuss in detail in my next modules. But as simply understand that CD is corporate debtor, it is a company or a LLP or a partnership. A special resolution of shareholders of 3/4 of total partners of CD is also required to initiate the IBC proceedings. The corporate resolution, now this is a very important provision, the time frame given in the IBC. It's very important. Corporate resolution process, CRP process, has to be completed within 180 days. It's a very very important provision. 180 days time is given for the complete proceedings. Further, 90 days can be extended on application of the resolution professional, but that 90 days has to be approved by 66% of the voting rights of committee of creditors. It cannot be done single-handedly. On admission, NCLT will declare moratorium. What is moratorium period? Moratorium period is that if once the application is admitted, all other proceedings, DRT, SARFAESI against that corporate debtor will be stayed. When the proceedings are admitted before NCLT, it is a public notice of initiation of CIRP process and call for submission of claims and appointment of IRP. Now, moratorium is declaration of prohibiting initiation or continuation of suits, proceedings, SARFAESI actions. Now, all these actions will come to the stay once IBC proceedings are started. As such, because if the proceedings are carrying on, that will lead to the multiplicity of proceedings, and assets will be like divided, because if assets are under IBC, they have to be solved there only. You cannot take simultaneous action under the SARFAESI and DRT. They have to be stayed immediately. They will be stayed immediately. And such prohibition shall continue till the completion of the CRP process. So this is a sole aim of IBC, that it will lead to the successful result. And we have seen that in recent years, so many companies have gone into IBC and the cases has been solved, or either the company has gone in liquidation, or if the resolution plan is not approved, it will go in liquidation, means the company will be sold off. On appointment of the interim resolution professional, management and affairs will come under him. All the powers of that company will be vested in the IRP, that is interim resolution professional. Now the company is no longer company, all the management power will come with IRP. This IRP will collect all details of asset, finances, and operation of the corporate debtor to determine the financial position, what are the assets of that company, what are the liabilities. His responsibility is to collect all claims which are filed by the creditors. He will constitute a committee of creditors. Who all are the creditors? They will form a committee out of those persons. The interim resolution professional, he will take every effort to protect and preserve the value, because this act was enacted with the aim to preserve the property, preserve the company, or the whatever the that entity was there. Its purpose is to preserve its value and manage the operation as a going concern. It is not for selling of that property. Its main aim is to preserve those assets. He can raise interim finance provided no security interest can be created on encumbered assets without prior consent of concerned creditor. Now, committee of creditor is after the IRP does the collection of the claims and determination of financial position, he will constitute a COC, committee of creditors. All financial creditors shall take part in COC unless and until they are barred by the act. And they have the right to vote in that committee of creditors. And their voting right shall be proportional to their financial debts. If their financial debt is like X, they will get that right. If their financial debt is more, they will be more powerful in the COC. First meeting of COC will be held 7 days after constitution of COC. So this procedure is very fast and it is very strictly adhered to also. COC, committee of creditors, either confirm IRP as RP, because the interim resolution professional will be designated as RP in the 7 days meeting only. In 7 days also, this committee of creditors will either confirm that interim resolution professional as permanent RP, or they will vote against him, or with 66% voting appoint another RP. The name of new person has to be approved by NCLT. First, it has to be approved by committee of creditors, and then it will go to the NCLT on recommendation of the board. Now, resolution professional will conduct the entire resolution Who will conduct the resolution process? Resolution professional. So he is very important person, and he will manage all the operation of corporate debtor during the process. He has to conduct the meetings where directors or partners, one representative of operational creditor may attend, but with no voting right. Voting rights, who is having the voting rights? Only the financial creditors, not the operational creditors. RP2, then what will RP do? He will prepare an information memorandum. He will invite prospective resolution applicants who fulfill the criteria specified in the COC and present all resolution plans to COC. Certain persons are not eligible to the resolution applicant. Who are not eligible to become resolution applicant? That is undischarged, insolvent, willful defaulters. Who is resolution applicant? Who wants to apply for that resolution? Who wants to bid for that resolution? Who wants to buy this going concern? So who is undischarged, insolvent, a willful defaulter, they cannot be resolution applicant. He cannot apply for the resolution. RP will examine all the resolution plans. He will provide for payment of insolvent resolution cost, payment of operational creditor in such manner, and which shall not be less than amount paid in the liquidation, implementation, and supervision of the. So all the resolution plans has to be first examined by the resolution professional. Only then it will be approved by NCLT. It will go in COC. COC has to approve it, and finally it will go to the NCLT for final approval. Now COC will approve that plan with 66% voting. 66 people have 66% of the financial creditor have to vote in favor. If 66% are not voting in their favor, this will not be approved. So RP shall submit the resolution plan to NCLT. NCLT, if it is satisfied with this resolution plan, he will approve it, and if same is binding to all the stakeholders. If NCLT is not satisfied, he can reject it. On approval, moratorium order will be finished, like it will cease to have effect. Now you can take the proceedings under the DRT and SARFAESI. Because when these proceedings are over, still our dues might be pending. So we can take action under DRT as well as SARFAESI. Resolution applicant will have to obtain approval required within 1 year. The creditors will get their dues as per the approved plan. So this is a speedy recovery. Now, if the resolution plan is failed, then what will happen? The company will go in liquidation. Liquidation means it will be sold off, and the assets will be distributed as per the water mechanism under section 53 of IBC. In that water mechanism, it is given who will be getting the first, who will be in the first layer, who will be in the second layer. These will all be dealt in details in the modules ahead. If no resolution plan has been accepted within that time frame, or RP informed NCLT about decision of COC for liquidation, NCLT shall pass the order accordingly. RP may allow to continue as liquidator. That RP will continue as a liquidator also, because liquidation is a second phase. First is resolution. If the resolution is successful, that resolution plan will be implemented. But if the resolution plans fails, the company will go in liquidation. Then liquidator will be appointed by the NCLT. Then same procedure, power and what will be the power and duty? He has to verify the claims. He has to take all assets in his custody. He has to evaluate it. He has to sell it, and by way of public auction, private contract, to invite claims, and all those proceedings as per the IBC Act. Now, secured assets in the liquidation proceeding, he can relinquish its security and receive proceeds by sale. Secured creditor then realize its securities in accordance with law and apply the proceeds to recover the debt dues. If secured assets fail resistance from CD in taking possession, selling, or otherwise, he can again move the NCLT to facilitate. NCLT is always there for this secured creditor. If there are surplus amount in such realization by way of security, it will be returned to the liquidator. If that amount has been distributed and still the surplus amount is there, that amount will go to liquidator. How the proceeds will be distributed? Notwithstanding any provisions of law, the proceeds from the sale of the liquidation assets shall be distributed in this order. First, it will go for the insolvency process में जो cost लगा था, whatever the cost and cost of liquidation will be fulfilled. Second, workmen dues proceedings 2 years from the liquidation. Third, wages of employees. Fourth, dues of unsecured creditors, then government dues, and sixth, any remainder shall go to the dues and amount of the, and finally the preferential shareholders, and then the shareholders and the parties. So in this way, the amount will be distributed. This is called waterfall mechanism. First, if it is saved, second, third, fourth. So waterfall mechanism is is not very good for the creditor, because they will get that amount will be decreased when they get the dues. That amount will not be the full amount which was due to them. So this is the drawback of IBC. When the corporate insolvency proceedings or liquidation proceedings are pending before NCLT, any insolvency resolution or liquidation or bankruptcy proceedings shall be filed before NCLT only. Okay, all proceedings in this regard all proceedings regarding NCLT insolvency which were pending in the different forums, they will come to NCLT. NCLT will have the powers of DRT in this regard as contemplated under the Part 3 of IBC. So this is again a provision for avoiding multiplicity of proceedings, because once the proceedings are with IBC, the other proceedings are stayed, and if similar proceedings are pending in some other courts, they will be transferred to the NCLT. Now this is just a comparative action, that if suppose the loan to the government agencies are not registered, what action you can take? You can take action under DRT. Not SARFAESI you cannot take. IBC no. Suggested action is DRT. When the government agencies are there, you cannot go for SARFAESI, and you cannot go for the preferred action is DRT only. In government agencies, you cannot take these actions like IBC and SARFAESI. But the loan to the government agencies which are registered with the Companies Act with government guarantee as secured, GG is government guarantee. In that case, you can take DRT action, no SARFAESI, because the security here is government guarantee. And I told you earlier, in SARFAESI action, the action can be taken against only secured assets, means like mortgage assets, hypothecation. But in case of GG, such secured assets are not there. So you can go for a DRT or IBC proceedings, but not SARFAESI. Loans to the government agencies registered with Companies Act with mortgage and hypothecation as security, you can take DRT action, you can take SARFAESI action, and you can take IBC action. Okay. Individual loans to the private corporate agency with security of mortgage, in that case you can take DRT action, you can take SARFAESI, and even you can initiate IBC. But in the IBC provisions for individual debtors has not been notified yet. So that has to be notified. Provisions are given in the code, but still they are not notified. Joint or consortium loan to private corporate agency with security, you can take DRT action, you can take SARFAESI, you can take IBC. If actions under IBC initiated by others, Now, retail finance loans to individuals on security of mortgage and personal guarantee. What action you can take? You can take DRT action. Yes, if the dues are more than 220 lakhs, DRT action is only applicable if the dues are more than 20 lakhs. Below 20 lakhs, you cannot take DRT action. You can take SARFAESI and you can take IBC action. SARFAESI and DRT action if due 20 lakhs and above. IBC action if dues below 20 lakhs to avoid filing of civil suit. These are for individual, but still those these are still yet to be notified. So I will not discuss in detail. We will discuss about the corporate debtors only in our next modules. Thank you.
Thank you, ma'am. Thank you so much for a wonderful session on recovery proceedings under IBC, SARFAESI Act and DRT Act. I hope the academicians, students and scholars will surely get benefited from it. Ma'am, how are these topics essential and important for students, scholars and academicians in practice?
If the students are going for practice in DRT,
or
they will go for the they want to practice in this field of law, because DRT, SARFAESI, all these proceedings are very beneficial for these financial institutions. If they are going for job in the financial institutions or banks, they have to be well aware of DRT and SARFAESI. So it will be very beneficial for them. And IBC, as you know, it's a very upcoming law, and people are going for practice in IBC. So if you are getting that opportunity to learn about this act in a very comprehensive way, so it will surely benefit the young lawyers, the students who are practicing law, who are learning law, who are in law colleges, professionals even, they will be surely benefited. And I can share my experience because I am too working in a financial institution. So I can share my practical experiences also.
Thank you, ma'am. Thank you so much for joining for this session. I hope we will have more sessions with you. Thank you.